This hearing wasn't just about probation rules. It was about whether the defendant would get one last chance. The court had already seen mistreatment, failed programs, and repeated issues. And now the judge had to decide, help or revoke everything.
Because she was not on the mental health caseload.
Right.
And so I know probation, they were supposed to go give them information regarding that, and they sent an email to the court.
And so I'm going to take, good morning, or good afternoon, I can't do afternoon. Are you Almeida Miles? And so we reset Miss Miles' case for sentencing. This is 24 DCCR 2330, and Miss Miles is currently on probation. And a motion to revoke that probation was filed, and we were here, it looks like, February 24th, and Ms. Miles entered pleas of true to counts 1 through 4 in that motion. The underlying offense is tampering or fabricating physical evidence with intent to impair, a third-degree felony. And we reset, it was unagreed, and we had probation. Ms. Joseph is here with probation, find out some information with regard to whatever, I guess you could find out with regard to any type of mental health services or information. And it looks like she has not received any outpatient services with Spinal Tap, that they referred her to the outpatient clinic, but you did not see where she'd ever actually had an appointment. Is that correct, Ms. Joseph?
Yes, that's from the mental health staff with Spindle Top. They said that she never showed up.
And so it does look like if I were to continue Miss Miles on probation, that Miss Joseph spoke with a Dominique Mayfield who supervises the mental health initiative caseload, and that she advised that she would make the Tacoma referral, and that Miss Miles could receive treatment that way. Is that correct?
Yes, ma'am. But everything is contingent on Miss Miles.
For sure. Yeah.
We could make services available, but if she doesn't follow through.
Totally agree. So timeline on, so part of the problem is that we sent Miss Miles to the ISF program, and that didn't work out. But the argument was that potentially it's because there were some mental health issues that had not, that's the argument. I see Miss Joseph is a little leery about that by her facial expressions. So I guess Mr. Smith, what is any thoughts?
Well, we tried to send her to ISF and she did not complete that program.
So Miss Miles, the last thing I want to do is not address something that needs to be addressed if there's some mental health issues. But I also don't want to be played and use that as a reason for me to continue on probation when that's really not why you violated or couldn't get through ISF. Does that make sense? Ms. Holmes?
I would be requesting that the court give her a chance to receive the mental health services. My apologies.
Okay. Of all times for it to happen.
Sorry about that. But I would like to see if she could receive the services. It looks like the history with her being on probation and does have a lot to do with how she handles situations, attitude, things like that, which I think.
The attitude and mental health are two different things, and that's where I am. That's my issue here, is this just a bad attitude problem, or is there really a serious issue that needs to be addressed? From the ISF documents, it looks pretty much like an attitude problem and not a mental health problem. Ms. Joseph, anything to add?
I don't deny that Miss Miles has mental health issues, but I don't subscribe to the fact that the behavioral issues at the intermediate sanctions facility, coupled with the disciplinary infractions at the county correctional facility, constitute mental health issues. However, it should the court elect to continue Miss Miles on probation, that the full plan is, and everything is already in her conditions of probation, she will be transferred to a mental health caseload where that officer can get the Tacoma referral. And if everything goes well, she'll be supervised on that caseload for a year. Then she'll come back to my caseload where she'll be supervised again for a year and to assess her progress before we transfer her to a regular felony case.
All right. So here's what I'm going to do, Ms. Miles. And it probably could potentially be easier for you if I didn't do this, but here's what I'm going to do. You're going to have one opportunity at this. All right. And I want to make that very clear because Ms. Holmes is listening to me. Mr. Smith and Ms. Joseph knows that when I say this is your opportunity, this is it. If you don't take advantage of what I'm about to do, there is no ISF, there's no special needs safety, there's none of that. I don't want anybody coming back and asking me for any of that. It'll be a revocation and it'll just depend on what I decide to do based on the information that I have at that time, how long you go to prison. But you'll probably be going. Do you understand? So they're going to give you all the help you need. It's up to you to take advantage of it, just like Ms. Joseph said. So I'm going to find that you entered your plea on that motion to revoke freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I am going to continue you on probation. I'm going to order everything that Ms. Joseph just said. You will be on the specialized mental health caseload. You will get a referral to the Tacoma program. They will explain all of that to you, and you will be required to go to every meeting, follow through with any medication. All of those are now court orders. So whether you think you need the class, the meeting, the counseling, the medication, at this point, I'm ordering you to do whatever they say is best for you. You will be on zero tolerance. So what that means is that there's no, I just missed a meeting or I just missed something, give me another chance. This is your chance. If you mess up, you'll be right back in here, even just with one mess up. Does that make sense? All right. Anything else, Miss Joseph, that you think would be appropriate for me to order?
I did want to clarify that upon her completion of the MHI caseload, she'll come back to high
yes.
Okay.
Then you'll go from the mental health caseload to the high medium caseload. That way you're not going from one super intensive to just kind of once a month. You're going to have a structured kind of step down process so that everybody can make sure that you're doing and everything you're supposed to, and that you're in a place where you're able to do that. Or if you need any further help, they'll get you that as well. All right. The disrespect and all of that, there's nothing that I can tell from any of the reports that I have that would show that there's some reason, mental health wise, for you to act the way you're acting at some points. Right. So that's not making you do some of those things. So I want you to be respectful to wherever you're going, the probation department, Spindletop, wherever it is. You have to treat everyone with respect along that way, that path. Okay. I'm going to hand you the trial court certification. This shows this wasn't an agreement. There are some rights to appeal, but you can talk to Ms. Holmes about that. If y'all will sign that and give her the bottom copies.
Okay.
And I hope you take advantage of this opportunity. Okay. Good luck to you, ma'am. There he goes. All right, sir, you're Justin Joseph.
Yes, sir.
And Mr. Joseph has two cases on probation, in each of those cases with motion to revoke filed. We've got cause number 20-35476. The underlying offense is possession of a controlled substance. And then we've got 20-35818. Underlying offense is evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, I will visit actually, Mr.
At this point, the discussion shifted from legal technicalities to behavior and responsibility. Was this truly a mental health issue requiring treatment, or repeated non-compliance with court orders? The judge had to separate explanation from accountability, carefully and firmly.
It was them that my client, I think we were here previously, we had a bond hearing a few weeks ago. At this time, we're at an impasse agreement wise, so this is what I think we have a hearing on this for us.
Do you want to go ahead and go through that motion and get
Yeah.
pleas of true or not true today then?
Set up.
Mr. Joseph, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand down. And will he waive the formal reading of the motion in each case?
He does.
So I'm going to go back through. Yeah, that'd be good, probably. And I could probably do it on two. Actually, I need to. I'm gonna print it, this one also, just because it's easier. All right, ready? All right, and so, Mr. Joseph, in cause number 20-35476, I have a motion to revoke your community supervision. Shows that you were placed on probation July 11th of 2022 for the offense of possession of a controlled substance, a second-degree felony, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
And then in cause number 20-35818, I have a motion to revoke your community supervision. This shows that you were placed on probation that same day, July 11th of 2022, for the offense of evading arrest or detention with the use of a vehicle, a third-degree felony. And that was also a 10-year term in prison that was probated for 10 years. Is that also correct?
Yes, Your Honor.
Each of these motions allege that you violated your probation. Count one in each case alleges that you failed to submit to alcohol and or drug screening on November 4th, December 1st, and December 12th of 2025, and then January 2nd and January 12th of 2026. And is that true or not true?
True.
Count two in each case alleges that you failed to submit a valid urine specimen for alcohol and or drugs, in that on January 14th of 2026, you attempted to provide toilet water from the urinal instead of your urine. Is that true or not true?
Not true.
And then count three in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 3 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those because they're both actually true?
Sure.
And do we have here we have probation here, but you wouldn't have been the one that did that testing. Is that correct?
No, ma'am, that was Officer Menard.
Okay, so what I'm going to do is find in each of your cases that you entered your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probations. However, I'm going to reset your case for sentencing. We can get an updated pre-sentence report. Mr. Nichols can have that officer here to testify with regard to count 2. And then we will go forward at that time with any sentencing. And there is no agreement. This is unagreed, correct?
Yes, ma'am.
Okay, we'll see you back at sentencing. You're Caleb Jubert.
Yes, ma'am.
And Mr. Jubert was previously in court, entered pleas of guilty in cause number 25 DCCR 1130 to unauthorized use of a vehicle, a state jail felony, and then cause number 25 DCCR 1131 to the third degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review it?
Yeah, Judge.
I have, Judge.
Are there any additions or corrections?
No, Judge, not at this time.
Only that the state concurs with the recommendation of the ISF cognitive judge.
All right, thank you, Ms. Malfino. All right, Mr. Jubert, I am So, Mr. Jubert, I know you know this already because everybody out there knows that I get the jail reports, right?
Yes, ma'am.
So there was an issue pretty recently. You haven't had a lot, but just recently you had earlier this month one about a mattress, right?
Yes, ma'am.
And you weren't very respectful about what you said to that officer when they said for you to give up one of those mattresses, were you?
Yes, ma'am.
So it's the same thing that I say to everybody. If you can't follow the rules in jail, then it doesn't give me a lot of confidence that you're going to be able to follow the rules on probation. Does that make sense?
Yes, ma'am.
So part of this agreement or part of the recommendations in this agreement is for me to go along with giving you probation, but send you to the ISF program, the cognitive track, which is a program to help you make better decisions. But I want you to understand if I follow along with this agreement and you get any more incident reports, either here or at ISF, it's going to be a violation of your probation and you never get out of jail before you violate it. And I know you've been out there long enough to know that I've done that already, right?
Yes, ma'am.
Okay. So then what I'm going to do, Mr. Jubert, is give you this opportunity. I'm going to find in each of your cases that you entered those pleas freely and voluntarily. In cause number 25, DCCR 1130, find sufficient evidence to find you guilty, but I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. And then in cause number 25, DCCR 1131, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings for 5 years. You're ordered to pay a $300 fine in that case and to follow all of the rules and conditions of probation. One of those conditions in each case is again that you enter and successfully complete the cognitive track of the ISF program. Also, there's going to be you're going to have a couple of assessments done just to see what all probation needs to offer you so that you can be successful. There's going to be a mental health evaluation, substance abuse evaluation, and if there's anything in those evaluations that say that you need some further treatment for whatever it is, then it is going to be your responsibility to do that and part of your probation. Do you understand?
Yes, ma'am.
You're going to get all the tools that you need to be successful. You're young, you don't have felony conviction on your record right now. If you successfully complete these probations, you will never have a felony conviction. This is a great opportunity. But the other side of that is if you violate any condition and you don't take advantage of the tools that are going to be given to you to be more successful, you're going to be right back in here in court. You're going to be looking at up to 2 years in a state jail prison in one case and between 2 years and up to 10 years in prison on the other. You understand?
Yes, ma'am.
Again, I want to make sure I reiterate how important it is not to get in trouble in jail while you're waiting on ISF and not to get in trouble while you're at ISF. If other young men are out there acting up, you need to say, look, I want to see the light of day again. Y'all go do what you're going to do. And I'm going to today sit on your bunk when you're supposed to sit on your bunk. Don't sit on it when you're not supposed to. Have whatever you're supposed to have. Don't have extras. Just follow the rules. And if you're called out for not following a rule, don't get mad at the person that's calling you out for not following the rule, right? You're the one that's not following it. So don't get mad at them. Okay. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed. So you have waived your right to appeal. Good luck to you, sir. I hope you do well.
Thank you.
Let's see. John Lamel. Good afternoon, sir. Are you Andre Williams II? And Mr. Williams' cases are set for trial to begin with jury selection next Monday in cause number 24 DCCR 2286, charged with murder, and cause number 24 DCCR 1539, charged with tampering or fabricating physical evidence with intent to impair. What is the announcement?
Your Honor, I'm asking for more time. Let me try and articulate to the court why. I am still trying to obtain Mr. Williams' records, his social security disability.
In the end, probation was not revoked, but it came with strict conditions. 0 tolerance. Mandatory treatment. No excuses moving forward. One mistake now could send everything back to prison.